I think it's a timely invitation since it's Family Month for us to talk about the legacy of what will be here and what we are leaving for our family. And it is something worth looking into because at my office, we have thousands of files sitting there, waiting sometimes for beneficiaries to come forward, waiting for children to get the names of fathers on the birth certificates, and it's just a quandary of problems. So we urge you to make a will, do any type of prudent estate planning that you can, so we can alleviate some of these burdens. Because as Pastor rightfully said, there are a majority of the matters that you see persons out here killing each other about. It's over land and it's over other things. So my colleague will be doing the presentation this morning. I think he's just getting the visuals up. And yeah, we will have will forms and brochures at the back after. So if there are any questions you might need to ask, we'll be glad to clear up anything for you.
Thank you very much for the introduction. And this is part of our Family Month activities. And we are actually closing Family Month. So we believe in the family. We don't always get everything right. But we're glad that you are here today and we are going to make it happen. Blessings.
Thank you, thank you. Good morning, or is it good afternoon? Good morning. All right, so in keeping with the theme, I'll be presenting on estate planning, securing your legacy, as was ably presented by the speaker. I must say, well done. The message was practical. The message was potent, but practical. There are times when presenters are eloquent and the message go over your head. But trust me, it was very practical. Yes? So, estate planning. What is estate planning? We heard the message, and there's something in it that told us what is estate planning. But before we do the estate planning, we need to know what is the estate. What is the estate? Right? Now, the estate is the net worth. It is the net worth of the individual, including all lands and possessions owned or entitled to. Yes? But why is it the net worth and not just the asset itself? Because the net worth is what you have. When you have assets, your liabilities, your debts, and from the Administrator General's standpoint, we have a thing what we call estate duties. The fees and the charges of the court and the lawyers and my office. So all those debt duties diminishes the value of the estate. So what does your beneficiaries get? The what left? The residue. That's the legal term, the residue. But I want to be practical, so I'll say the what left. Right? Because the asset is affected by liabilities. Now, the estate planning is the process of anticipating and arranging for the disposition of those assets during your lifetime. Right? It allows for the management and disposal of your asset during life as well as after death. Right? So it must be done when? While you are living. While you are living. Yes? Scripture says the dead knows nothing. Neither can they do anything. So you can't plan after you die. You have to do it before. It is the process of planning for incapacitation. Yes? So, just as was presented, it is not only the physical legacy, but it's also the spiritual legacy. It's not coming up. I was trying to get the projection for you to follow, but it's not coming up. Right. So it's allowed for you to make the planning whilst you're alive for all eventualities, not only death, but also incapacitation. Right? And it allows for you to determine what you own, who will get it. Yes? Who gets it? Because when you don't, the government, which is the law, makes that determination for you. Huh? Which one you prefer? You determine or the government? Without a doubt. So you must consider what you own, but also of necessity, who you owe. Because if you owe Master Joe, he can come calling on your assets. So what you dead left for your children and grandchildren, the debt that Master Joe has consumes your asset. Therefore, nothing left for them get. Yes. You must also consider if you have children. Oh, it's up. Good. All right. Proceed to the third slide. Things to consider. Proceed to that slide. Things to consider. All right, so I'll proceed until you get there. Right. So, those of us who have minor children, we need to put plans in place for them. We have seen where persons die and the children struggling to go to school because nothing was in place for them. You know what that means? Them lose out upon the opportunity of education. Right? And in today's society, we know the meaning and importance of a good education. Right? We must also look at the current state of our affairs, whether or not the plans that we now have mirror our current situation. Do the plans we have from yesteryear make provisions for today and tomorrow? We need to look at that. Something to consider. Right? So, also, let's look at some of the things we can do for estate planning. Right? One was mentioned earlier about making a will. Making a will. Do we know what a will is? All right. Enough of us don't want to make the will because we're not ready to die. Because we think that when we make the will, yes, we're going to die. All right, so these are things to consider. Yes. Yes. So, things to consider. You can make a will, right? You can have joint ownership of property. You can create a trust. You can have life insurance with named beneficiaries. You can have health care. A lot of people don't know this. You must also plan for the health, the illness that follows the life. Yes? Because what happens is that a lot of us, our wealth is eroded by our illness. Yes. The wealth we have is eroded by the illness. We have to sell the car and the house and empty the bank account for the treatment. Yes? Worse if it's the cancer, who's very expensive, that dangerous one. Yes? Or some of us have some physical disability where we need therapy. And we have to go for weekly therapy. For those of us who have renal disease, that we have to go for that daily or weekly treatment, dialysis. You know those things are not cheap. Not cheap. Right? Another thing that we can do, a power of attorney. How is that impacting estate planning? Because, as I just mentioned, illness, incapacitation, right? And simply, right? Being away. Some of us have to go away on business, etc. But we have things that need to get done. So we can create a power of attorney. So this person will now run the errands, get all the things done whilst we're away. Right? There are persons who are incapacitated and cannot go to places that they need to. Right? So if you are a pensioner, I've seen senior citizens struggling to get to the post office. Struggling to go to the post office for their pension. Next slide. What is the will? It's the last will and testament. It must be in writing. It must be in writing. The intentions stay here. And if they don't go to the paper, then it goes to the grave. Right? So the intentions, we hear it very often. Every day we hear it. Him did say. Papa did say. Mama did say. But that don't count for anything, you know. Because the words are gone with them to the grave. Right? So it must be in writing. And of importance, what does it say there? It sets out for the distribution of your assets upon death. The will is of no effect whilst you're alive. Let's hear what Hebrews say. Next slide. So Hebrews tells us that for where there's a testament, there must be of necessity what? The death of the testator. Right? Because it is of no force whilst you're alive. Yeah. But this is the fear most people have, that if somebody see their will, they're going to kill them. Because you take too long for die, man. Gosh. You're sick and bedridden for 2 years now? Well, you wait, man. Hurry up, man. Jesus will call you. All right, let me help you. Let me help you in transition. Wow. All right, next slide. Why should we make a will? Why is it so important? Your intentions are clear when they are in writing. Right? You get to choose your legal representative. Otherwise, the government assumes that responsibility. Yes. And you get to choose how your assets are distributed. Right? Shorter turnaround time. Yes, it does. When you have a will, it takes a shorter time to get the administration done. Where there's no will, we have matters at my office for more than 20 years. Yes? For simple disagreement. And the law also says that we have to keep an estate until the minor reaches 18. Because there's no will. All right? So if a person dies and the child is 1 year old, 17 more years to go. Yes. Now here's the problem. When we have to administer an estate for 17 years, that is 17 years of cost to the estate. Do you realize that? It scares me, you know. Every time I say it, it scares me. I don't know why, and I have my will. But I'm just imagining, because I sit at the desk and see these things daily. Daily. Yes. All right. Next slide. Who is the testator? You, the person who is making the will. You are the testator. You get to determine what you want. Now, here's the thing about making the will. Some persons As was read in Proverbs, leave something for your children's children. But you must give it away. Don't create a perpetual gift. A perpetual gift goes nowhere, and it stays there and rot. It rots. The reason being is that it causes conflicts, war over deadlift. People are kill people, and we're not talking about stranger now. We are talking about bloodline. Brother and sister are kill each other. Because the perpetual gift occurs when you say, I give it to my children, and after that, their children, and after that, their children's children. When you do that, it remains for 10, 20, 30 generations. Right? The problem arises where one person wants to have dominance over something when it belongs to him. It belongs for everybody. Right? And we have had cases where the person who is at the property is denying entry to the other persons. But it was given to who? The children and their children's. So even the third, fourth generation can come. Right? But the one who resides there always tend to apply dominance. Lack of knowledge too. Because the one who lives there is ignorant that the law says those persons are also entitled and they have right to come. But because they live there, you know what happens now? Is if them fix up the place, you can't come in it. Yes. So if I come to you and ask you for some money to fix it up, you rightfully say, "What are you live there, Sir Morris? You must fix it up." That's all right, no problem. So I'll fix it up. But you can't come in here after I fix it up. You see the conflict? And that's how the war starts, you know. Because it's either me pay somebody to take her out, or she pay somebody to take me out. And we are Jamaicans, so we know what take out means. We're not talking about fast food, no. No. And we're not talking about going out to dine. Yes? All right. Means permanent sleep. All right. So the testator must have the capacity, over 18, and very importantly, sound mind. So if you have a relative who is not of sound mind, right, who is of sound mind, they cannot make a will. They cannot make a will. Sound mind means any form of mental disorder, mental illness. Yes. So even if a person is on their deathbed, right, it can be questioned as to their mental capacity. Why? The state that they are in, right? You will have to prove that they are mentally sound. Yes. All right? So, of course, this is subjected to medical proof, meaning that I can't say, Papa, all and every minute him forget what I'm telling him. That's normal. That's normal. Right? Who remember the theme of the speaker? Who remember the theme of the speaker? Very few persons. So the rest of them have mental illness. That's a simply practical application. Who don't remember have mental illness? Your thing falling. Yes. So it simply means that mere forgetting things is not a mental disorder or disability. Yeah? So it must be medically diagnosed by the professional. Yes. Also, right? It says that the person must be free of fear, fraud, or flattery. You can't threaten the person. Right? So here's big sister, and she's sending all the remittance to mama. And she going to tell mama, say, if she not put her in the will, she going to cut off that. Huh? That's a threat. That's a threat. Right? That's fear. Flattery I will encourage mama to give me, so I'll take care of her because big sister is away. And me and you there, give the house to me. Why you put her upon it for? She don't need for this. She don't overseas or live life. That is it. Flattery, coercion, right? No esteem words. Remember, yes. So if I encourage her to give it to me, that's flattery. So the fraud come in now, where I forge mama's signature. I squeeze in my name because mama left me out. And papa didn't put me in the will because me and papa not talk. All right? Yes. So, the will must be signed in the presence of 2 witnesses. Now, these persons must be present at the same time. The Wills Act says that if they are not present at the same time, the will is not valid. The Wills Act is the law of the land that governs wills. Right? So if they are not present at the same time, the will is not valid. Watch this now. So let's say pastor is making the will. So him come over to the left and sister here sign. And then him go over to the right and sister here sign. They are not present. No, because neither would have seen the other sign. Right? I know she's over there signing, but am I present? So it must be present. Yes. Right. Now, a will have several clauses. Right? There's the revocation clause that says all previous will, next slide, yes, right there. All previous will made by me is hereby revoked. Because it is the last will and testament that counts. Right? So of importance now is the date. That's how you're going to know the last will. So you must date it. You must date it. Next slide. The will should have what you call a residuary clause. The what left clause. Right? This means after you dispose of everything, whatever remains. It's called a residuary clause. You see, this clause now will treat with anything that you would have forgotten to include in the will. It also treats with anything you acquired after making the will. Right? So if you went out and buy a new car and you forgot to write over the will, once this clause is present, it deals with that. If the clause is absent, then it cannot treat with the new car. So what it means that there are some of your assets that is not distributed. So it comes under the law of intestate. That is where there is no will. So where there is no will, it is called intestate. And the law for that is the Intestate Estates and Property Charges Act. Right? We're going to get into that later. Next slide. Duties of an executor. Who's the executor now? That's the legal representative of you, the testator. Why do you need an executor? So the asset of the deceased must be transferred from owner, who is deceased, to beneficiaries. Right? In order for that transfer of ownership to take place, there must be signature. Right? In life, the owner can transfer to the beneficiary by signing. In death, it's the executor who signs for the owner. All right? Yes. Now, the executor must be somebody you trust. Not just anybody willy-nilly. Somebody you trust. Right? Everybody trusts pastor, right? So, pastor, you have a lot of wills to be executor for. But pastor can be burdened. Pastor can be burdened. So pastor will take the escape route and renounce. So the best thing, make your beneficiaries their own executors. Why? There are times when the executors, right, if it's a neutral person, as I just said with pastor, and him burden and overwhelmed, then the pastor might delay. There are times when executors migrate and they can't bother to come back. There are times when the executors die. But the beneficiaries cannot do anything. It is the executor who does it. So when the beneficiaries are their own executors, they can take matters in their own hands and they can move quick. So a beneficiary can be an executor. Right? Yes. Where the beneficiary is not an executor, he or she is entitled to a fee of 6% of the value of the asset. The gross value, not the net value. The gross value. Right? Yes. The executor is the one who distributes the assets from deceased to beneficiaries. But hear this now. The executor is the one who collects the assets and settles all debts. You remember what the estate is? The net worth of the individual. So when the person dies, the debt don't die. No. There are persons who think that Master Joe owe you and Master Joe die. That's the end of it. No. You just need to know what him own and make a claim. All right? So the executor in the case of a will has to settle that claim. So what if there's no money? The executor goes to the beneficiaries to get the money to settle the debt, to then transfer the property to the beneficiaries. What if the beneficiaries don't have the money? The executor can sell the asset. The executor will have to sell the asset to settle the debt. Yes. All right. Next slide. The witness. Who is the witness? The persons who sign in the presence of the testator, the two persons. Right? Now, a witness doesn't have to be a JP. There are a lot of persons who think that your will must be signed by a JP. No. You don't need a JP to validate your will, meaning to approve by signing and putting a seal. You don't need that. Why? The justice of the peace are supposed to approve of statutory declaration by law. A will is not a statutory declaration. So you don't need a JP to approve by signing and put your seal. But a JP can be an effective witness. There's no need for the seal or stamp. All right? Now, a witness should not be a beneficiary under your will. Earlier, we said that the testator should not be encouraged or threatened. Right? A witness takes such a position to see the will because they have to sign. So because of that proximity, that closeness, the law says for a witness to get a benefit under a will, they have to go to court to prove to the court that they did not threaten you or encourage you. Coercion. Therefore, it may cost this person more than what the gift is. All right? Problem you create right so. So, most important, your witness should not be a beneficiary. Next slide. Revocation of a will by marriage. Yes, if you make a will and you subsequently get married, as at that date of marriage, the will is not good. The law says that. The law, the Wills Act says that. The will is not good. Right? Next slide. Also, the will can be revoked by tearing it up or destroying it. We have what is called under law a grant. This is not a monetary grant. There are several times when we do this and persons ask, how much is the grant? Because you know a grant to be like a monetary gift. But this is not so. In estate, the court gives what is called a grant. It is the authoritative document, basically the authority of the court given to an individual for them to deal with the assets of somebody who died. To the executor of the will, the law gives what is called probate. So the probate is what allows the executor to sign for you who is dead. Without the probate, he has no authority to sign. Under the law of intestate, where the person makes no will, where the person died, did not leave a will, it is called intestate. And the law gives a document called letter of administration. So this is the document that allows an administrator to distribute of the assets of a deceased. So the terms are different according to the law. Where there's a will, the legal representative is called an executor. Where there's no will, the legal representative is called an administrator. Right? So where there's a will, the court gives a probate. Where there is no will, the court gives letter of administration. All right? And that is what allows to deal with the asset. Now, before we get to the intestate, where you make the will, you get to determine who gets what. Understand? You determine who gets what. No. When you don't make a will, the law say who must get it. Right? The law go further to say how much you are to get. The law go further to say who are the persons who can get. And if you are not included in that, you don't get nothing. And the law go further to say, if you who are alive are not eligible to get it, it goes to the government. It goes to the So here it is that you would have worked all your life for this property. But because you didn't make a plan, the government get it. The government don't get it because you don't have no relative, you know. The government get it because the law says those relatives should not get it. You realize what I'm saying? The law makes that determination, ladies and gentlemen. Now, how would you feel for that to happen to you? So making a will, you determine who gets it. And of course, you can also give a gift to your church. To your church. Whether it's a gift of property or a monetary gift, you can give to your church. Right? Don't forget that. Don't forget that. So would you rather the government get it? If you don't have any relative, give it to the church. The church can use it to proclaim the gospel, to help the less fortunate. You name it. The church will find use for it. All right? When you make a will, be careful in your statements. You must describe the what it is. Don't say my property. Identify the property. Give a description. This is what? Brumelia Road? 5 Brumelia Road. My property at 5 Brumelia Road, Mandeville. Right? Give the address. Right? If it's in the district, in the remote areas, there is a thing called a lot number. Identify. If you don't know, go to the tax office. Go to the National Land Agency. Go to the parish council. Right? Those entities should know the lot number. Yes, that will be on your title. Yes. But there are those properties that we call unregistered. There's no title. So you use the lot number. Right? Now another thing, you must identify who must get it by giving the person's name. Don't say my children. Give their names. Right? And you must identify how they share the gift, whether equally or dividedly. 10%, 10%, 50, 20, and so on. Who gets how much? Next slide now. So we're going to the intestate slide. Next slide. This is called intestacy, where a person died, did not make a will, or where you have assets that you made a will for that does not have a residual clause, and those assets were not included in the will. It comes under intestacy. Where that is so, you have to do 2 processes of administration. So you have to pay the lawyer twice, you have to pay the court twice, everything times 2. Understand? So it's important to have a residual clause in the will so you don't end up with a partial intestacy. Because that means it's 2 different acts of law. So it has to be 2 different processes of law. The next slide now. See here now, the Interstate Estates and Property Charges Act. Long title, right? But this is the law that sets out how your assets are distributed, to whom it is distributed, how much each person gets, and who is excluded from getting it, and where that is so, it goes to the government. Right? So, Section 4 of the law have a categorization of persons. Primary, secondary, and the next one, you see the next one? What it says. Don't pay any attention to that. That's just English term. No eligible relative. This is where the law excludes your cousins and third cousins and yes. Yes. So the law excludes them. Right? Yeah. But there's a remedy for that. I'll speak to it. Now, the primary beneficiary consists of 3 components. Spouse, which includes common law spouse. And for common law, it's single man and single woman who must be living together for minimum 5 years to be eligible as a common law spouse. For the common law spouse, that eligibility have to be approved in the court of law to get what is called a spousal order, yes, or a common law declaration. Yes. So, if the law says no, that the assets, it is the residue that is distributed after the debts, liabilities, taxes, and fees are extracted, are deducted, are settled. So it is the what left that your beneficiaries get. The what left. No. Of that what left, the first 10% of that goes to the spouse. right? And the spouse is entitled to interest thereon. I say spouse because it applies both for husband and wife. Right? So vice versa, if the man died, then the spouse is the wife. And if the wife died, the spouse is the... So I use spouse. Right? So the spouse gets the first 10%. The spouse is also entitled to what is called chattel. What is that? The law determines that furnitures within the home are classified as chattel. Right? I pause to say this. Let me interject this. You don't need to make a will to include furniture. The reason being, those things are easily removed. The day Papa died, 2 of the chairs missing. That missing. So everybody who come to grieve and mourn, I leave with something. Huh? So this is me. I say, boy, Sister Brown, my condolence. All right, see you later. So the thing is this, that those items, usually when it reach to us, they can't account for them. They can't account for them. They're missing. Huh? So you don't need to include those things in your will. Right? If there's a surviving spouse, it belongs to that person. Yes. Motor vehicle that are used for private purpose is classified under law as chattel. So if there remains a motor vehicle after all the bills and taxes and debts have been settled, then it goes to the spouse. So remember, it is the net worth that is the estate. So once there's a liability or a debt or anything, you cannot transfer the vehicle as chattel before those have been settled. So it is not chattel until it becomes residue, what left. Understand? So if there's money to pay all the debts and everything, and there's a vehicle that remains, it is chattel. If there's no money to pay those things, remember I said that the executor can sell the asset. It means the vehicle will have to be sold. Right? Yes. Firearm is a personal chattel. Firearm. Yes. Spouse is entitled to that. Yes. The spouse is also entitled, we still are talking about the spouse, 50% of the what left. 50% of the residue goes to the spouse. So if after the debt is $10 remain, the spouse gets $1 for the spousal interest. The remaining $9, the spouse gets a half of that. A half of that. Yes. Now, of the remaining half, if there are children, the children share the remaining half equally. But there's a third component to the primary beneficiary. Do we see who that is? Who is the third component to the primary? The parents. No, remember the spouse gets half of what left and the children get the other half. So what leave? What leave after the children get the what left, the remaining half? Nothing, no leave. But the parents are still there waiting, hands out. So the parents get nothing. The parents get nothing. Understand? Yes. So what if it's a spouse and one child? Instead of half, the spouse gets a two-third more. And the child gets the 1/3 that remain. The parents is still there with arms out. Right? If there's no spouse and there's one child, the child gets everything. Because you see, there's a priority under the primary. Spouse is first, children are second, parents are last. All right? So the last component, which is the parents, have to wait until the spouse and the children get before they can get. So if what remains is nothing, that's what they get. If what remains for the parents, then that is what they'll get. Right? Now, we're going to the secondary. Right? Oh, let me just finish with the parents. The parents comes into the picture. If the person dies, there's no spouse and children. So the parents will smile. Yes. So parents, there's hope. So we go to the secondary. The secondary component now comes in where there is no primary. Once there is a primary component, the secondary don't come into the picture at all. At all. You see the formality here? But the problem is this, that there are persons who forcibly take, and that's where conflict comes in. And that's where war over deadlift happens. So a parent may say, I spent 13 hours in labor for this child. And you're going to tell me, say, this lady who I'm just married to must get all of this. And me not get nothing? You see it? That's the ground for conflict right there. You know? Yes. Because remember, your parents is parents for how long? All your life. You can just get married to your spouse, you know. Just get married. But the thing is that for the spouse to qualify, all she needs is the marriage certificate. And at the day of the wedding, she signed the paper. That's it. From that day, yeah. Yes. There's no waiting period. You know, with insurance, you have to have a waiting period. There's no thing like that for the spouse. No waiting period for the spouse. All right? So the spouse will just come. It is like that. You see, the law is the law. So why I caution you is that when you're making your estate planning, be aware of the law. Be aware of the law. What if I should die leaving a will? Huh? What if I should die and don't leave a will? Who will be affected? Will your parents be affected? How will your spouse be affected? Your children? Be aware of the consequences of your action or inaction. All right? Because I remember there was this man in Hanover, and him say, my estate plan is no plan. When I die, whatever happen. I am not alive, so I don't business with that. I feed them business that. That's his plan. That's his plan. So whoever want to fight for it, kill for it, or him no business with that. Him dead and gone and him all right sleeping. Yeah. That's his plan. But you have to be aware that every plan have a consequence. All right? Consequence may be good or bad. Understand that too. All right? Yes. No. The secondary doesn't come in once there's a primary. All right? So, for secondary to come in, there must be no primary eligibility. Right? And the secondary are those that are stated. Siblings, grandparents, uncles and aunts. That's it. That's where it stops. So the law says the other relatives are not eligible to get anything. They are not worthy of getting anything. But there's an escape route. There's a loophole for them. Right? So the law now provides for such relative to make an appeal to the government. To the government. No, because we are still under British rule, though we are independent, still under British rule. So anything goes to the government, it goes to the crown. So the king or queen of England still own properties around, and we are giving them properties as well. So where it goes to the crown, your relatives now have to make an appeal to the representative of the crown, who is the Governor General. So the Governor General now sits and deliberates or determines whether or not you should get it. Right? So if the Governor General consults the Prime Minister or the ministerial body and said, would this property be beneficial to us? Yes, we can use it for whatever. Then the Governor General may turn down your appeal. To appeal is not necessarily that you must get it. An appeal can be either yes or no. Understand? So if the Governor General says, all right, fair enough, you can have it, then you can have it. All right? So that is it for bona vacantia. The next slide now, I'm coming down. Administrative fees. This is what a lot of people don't plan for. I leave the house and the car and everything. They just leave in the assets. But they don't plan for what we call in law debt duties. The transfer tax, yes. When you go to the supermarket and you buy goods, you pay GCT, you know, so? When you transfer property in Jamaica, the tax is called transfer tax, right? Where the person die, we just collectively call them debt duties, right? And these are some of them, right? So a lot of people don't plan for these things. So the estate only have the asset, but no money to pay its way through administration. So administration, once you die, whether or not you leave a will, your asset is subjected to debt duties if you die, and transfer tax and stamp duty if you're alive. Right? Yes. So that's just the taxation set up by the government. You won't get out of that. So as it is now, estate planning is to create co-ownership, as was, what should I say, potently addressed by the speaker. The Issas, the Matalans, you name them, the Stewarts, they don't have these problems because they have a strategy that works, that creates that generational wealth. But guess what? It's not beyond us, you know. It's not beyond us. We don't have to have this amount of assets to make a plan. No. You make a plan for what you have. Your generational wealth is for your generation. Theirs is for theirs. Understand me? All right. Let's say you only have this little. You are enjoying that little. And that's what you're going to leave for your family. But the thing is that we have to teach them estate planning. We have to teach them to be content. Yes? So you don't grudge the Issas and the Matalans for what they are doing. They are doing that because that's what they have. Right? And if we should trace history, you see how they acquire their wealth. Enough of them acquire their wealth through slavery. Yes. Right? But let's not go there. If you, not calling names now, there are a lot of wealthy people who inherit through the slavery, the plantationism that their family grew up into. That's what they inherited. Huh? My family is the Morris, and we inherit Manchester. Everything in Manchester belonged to me. That's what I inherit. So I know, make sure that I put things in place to ensure that my children inherit this. Huh? You only have 5 Brumelia Road. That's what you are going to plan for. You are going to plan for that. Right? So your estate plan should mirror what you have. Should effectively treat with what you have, however small it may be. Right? So to create an estate plan, right, can be at any level, every level. So that's what they are doing, and that is why they remain potent even today as a household name in Jamaica. Right? So we have to teach that to our children. Right? I'm creating this for you. And I want you to have this and to build on this. Because the truth is they can squander it, They can squander it. Yeah. They can. All right? But we have to be mindful also that our plans are effective for the now. So if we have assets from a previous marriage or relationship, we have to look at them. We have to look at them. Persons got married, they owned the house together, they got divorced, but they didn't file for separation of the house, only dissolution of the marriage, which is the divorce. The dissolution of the marriage is different from the separation of the asset. Right? So if you're divorced and you have assets with your ex, you need to change that. You need to change that. All right, next slide. So transfer tax is 1.5%. Right? And stamp duty is incremental from as small as 5,000 up to 25,000. Right? Depending on the value of the asset. Right? Next slide. The attorney's fee. Go back. The attorney's fee is plus GCT. You notice there's no figure there? Why? They can charge you according to their status. Yes. You have attorneys of status, It's not every attorney is just attorney, You have senior attorneys and you have KC. There used to be QC because it was reigning queen, but it's reigning king now. So it's now KC. All right? So when they have that status, their fees higher. Huh? Of course. Of course. So the attorney will ask you to declare what are the assets. And you will say, it's 5 Brunelia Road. What's the value? $5 million. The attorney will say, let me check my itinerary. I am fully booked. I wouldn't have time for your case. Because your case, a waste of time. That chicken fee that are going to cost me more the time and effort. A chicken feed. Somebody else going to give you an excuse that, oh, I am unavailable. I won't be able to touch your case until the next 3 years because I'm heavily booked. Yes, they'll tell you that. They'll tell you that, right? The attorney can't outright tell you that. No, sir, chicken feed that. No time for that. No, they can't tell you that. Because of the practice. There's some ethical connection to the practice. Yeah. So they have to be careful how they turn down a client. But if the asset is in the billions, that's a sure, I'll deal with it next week. Next week. Right? The executor's fee, remember I said the executor's fee is 6%? It goes both ways. It is the same for the administrator. Right? And miscellaneous fees, this is where anything can apply. Anything can apply. Right? For us, we charge for court appearance, but we don't put it like that to our clients because it's when the case gets to a point where we have to go to court that we say, oh, this matter has to go before the court. Yeah, I will tell them the why. Yeah. All right? So there are those estates where persons die and it is from a negligent act. So we have to go to court because we have to bring a case of negligence in the court. That is not an asset that is readily identifiable as a property. So we have to go before the court to argue that the client, the opponent, right, breach a duty of care. It could be accident or workplace related. Yes. So we can go to court to plead a fatal accident and call for an award. Yes. Next slide. So this is where the Administrator General's Department can assist you. Where persons die, leaving money in an account, did not make a will. Right? Because what happens when you make a will, the executor is the one who takes the case. So where the person died without a will, have money in an account, and you need that money to bury them, you can come to us. Right? Where the person died and the value of the asset is $1.5 million or less, we can deal with it. Where the person dies and the children are under 18, we deal with it until the child reaches 18. All right? I'm not going to go into that now because that will take us till tomorrow. Yes. When we do cases of intestate with minors, it is the hardest case for us. I'm telling you, it's the hardest case for us. Right? And you hear the speaker spoke about the minister announcing that we have estates that is just sitting there, billions of dollars. It's because of the conflicts in the estate. They are not in agreement. They are not in agreement. So it does have to sit there and deteriorate. All right? Next slide. Assume take your questions. Next slide. Estate planning. Simple. Set up joint ownership. Where you have joint ownership, if A dies, B continues the ownership. There's no need for a will. There's no need for an administration. These are the tools that the wealthy families employ. That is why the cases don't come to the Administrator General. All right? We have cases for celebrities, mostly the Rastafarian musicians who don't believe in the will. They have certain beliefs. I don't know, but those cases come to us. We have a lot of them, right? But the wealthy families, they do these things that you see here, that their family don't have to go through no court, to no legal battle to do anything. So father die, children carry on. And they repeat it. That's the beauty of it. They repeat it. That is how they have this generational wealth. They repeat it. Right? Yes, so these are simple things. These are simple tools that you can apply. Yes. All right, the last slide. Yeah, so have a basic estate plan. Basic meaning to your level. Right? Yes, to your level. Okay? And take an inventory of what you own. Discuss your plans. Put them in writing. And remember, at any time, you can amend your will. All right? Ladies and gentlemen, that's the end of it. Any questions? Thank you. God be praised.
Sister Peter Gay, please come. She's going to guide. And after she's through, then you know that we'll go home. So we are good.
Mr. Morris, thank you so very much. There's a saying that says, to be forewarned is to be forearmed. On a side note, a few years ago, Alistair, my husband, was going on to a conference. And he's like, come, let's go together. And I'm like, no, you and I are not getting on a plane. And we have 4 children and we don't have a will. So about 3 years ago, and it's funny because we travel to Kingston, Mobay together all the time, and they say the plane is the safest mode of transportation. But that going on that conference with him prompted us getting the will done. All right. So I do have a few questions here from the congregation. The first one, Mr. Morris. Does a deceased person's name have to be removed from the title of a property?
Yes, it does. Here's why. Any transaction, including such property, requires signature of the owners. Therefore, where A is dead, A cannot sign, right? No, who signs for A? If A makes a will, the executor of the will has to probate the will, getting the authority to sign for A. If A dies intestate, then the administrator of the estate, under letter of administration, will have to sign for A. Until that is done, no transaction can be done. All right? So owners on property must sign, have to sign. Yes.
Here's another one. How does a prenuptial agreement factor in will making?
It doesn't. It doesn't. The prenuptial agreement, right? You would have already set out what is available and what is not. So if you are going to make a will, the person would have signed to this agreement, right? Because it's an agreement. If you know going to make your will, you have the right to dispose of these assets, right? However, let me caution and interject here. Under a court of law, or in a court of law, a will can be contested. A will can be contested. So notwithstanding you have a prenuptial agreement, the person or persons can contest your will. Yes.
Another one. How are stepchildren facilitated when the estate was inherited by a step-parent?
Okay. With or without a will?
Without a will.
Okay. So where a person dies and there's a spouse, the spouse has an entitlement, right? Now that surviving spouse may have children, not of the union, stepchildren. These stepchildren will have no entitlement. No entitlement. So under the intestate law, where it says children, right? Children are by blood or adoption. Right? So children are biological, by blood, or by adoption. Adoption is lawful. Right? Foster children are not children. Stepchildren are not entitled. They are not entitled. Right? So I extend it to foster children because there are persons who will say, she grew me from year one. Right? And now she's dead. I must get something. No. She grew you from year one and now you're 50, 60, 70. You're not entitled to anything. Right? So children are only classified as biological blood or adoption, formal adoption. Right? But here's the twist and turn. Where the spouse gets the entitlement to the property, then the spouse can will that property to their children. So you see how stepchildren can come in? It's a harsh thing, and some of this we have to deal with, some of the conflicts, where stepchildren come into the estate through the spouse and creating conflict with the biological children. It happens.
And the final one I have is, should keep your will.
Very
Should it be
good.
kept?
Well, when you make a will, firstly, when you appoint your executors, you need to make them aware. A lot of people tend to just throw the title at you. The most logical person to get that is the pastor. When the congregants make their will, who am I going to make my executor? Oh, yeah, pastor. Right? Because pastor takes such a chair of that person who is prudent, trustworthy. Right? Yes. So a lot of persons, on their will, they put pastor as the executor. Poor pastor don't know nothing. Right? But the thing is, make the awareness. Pastor should have the opportunity to accept or reject. Whoever your executor is should be aware. And once the person accepts, you must tell them where you put the will. Right? Now you can keep the will in your keep and care, but they must know where. You can also give the will to the executor to keep if you think that your grandchildren or children or whoever will see it and take you out, then give it to the pastor or the executor, whoever that may be, to keep it. Right? Also, the Registrar General's Department offers a service of registration of documents. They won't keep your will. What they will do is register your will. Now, if you keep the original at home and it is destroyed, flood, fire, the executor needs to be aware that the will was registered. So the executor can go to the Registrar General's Department, get a certified copy. A certified copy. And here's the importance of that. The court admits the original will for probate. If the original will is destroyed for whatever reason, the court will admit a certified copy from the Registrar General. If you just have a mere photocopy, the court will say no. Yes.
I'm not sure if banks still have a safety deposit box. Could it be
Also, yes, there are institutions that offer such a service that you can use to safeguard your will. Right? Yes. But you can put it even under the mattress. Just make sure somebody knows, especially the executor knows where it is. Right? Yes.
All right, so we have 3 questions. Beverly Henry, Donna Treasure, Christine Morgan. Go ahead, Mrs. Henry.
Go ahead.
One is a simple one. Children. When the testator has children, this testator is a married person, and the testator has children outside of that marriage. Children are children.
Yes. So here's the important thing. I'm happy it's a lady who raised it, but it's more applicable to us, men. Right? Men, I'm addressing you now. Pardon me, ma'am, but I'm going to direct my response, my reply to the men.
Yes, fair enough.
To the men. Men, when we have children outside, and we know what outside is, we need to make provisions for them.
Yes,
Because oftentimes we
Yes.
don't.
true.
And this is ground for conflict.
Yes.
Because when they come calling, weaning when them come out of the bush, the wife is going to say, who you? I'll come push up both your picnic. Huh? Where you come from? And that means that the wife or spouse will exclude them. It may be seen as an act to disinherit them, meaning to shut them out of getting what they should get, what they may be entitled to. So we need to make plans for them. Why? They are children by no lesser means. The act was amended in 1976. Right? Yes, the act, the Interstate Act, was amended by the Status of Children's Act that allows for children of illegitimate means outside the marriage, illegitimate, to now be equal to those inside of the marriage. So that was abolished, right? So children inside, children outside are children.
Okay. All right.
Yes.
Thank you. The other question, I always encourage people to make will. The last time I was speaking to a gentleman, just a few weeks ago, I was asking him if he had made his will. And he told me that it is not important to make a will. The new thing is to create a trust. Can you explain that to us about this trust?
Yes. A trust is an effective instrument of estate planning. Most wealthy families have a trust. In that, they put the asset in the hands of the trustee with instructions. Upon their death, whether or not they make a will, most times they don't, because the assets are already in trust. What the trustee do, be it an institution or maybe an attorney, is to now distribute according to the instrument of trust and the instructions that are in it. Right? So if it says that the property at 5 Brumilla must go to you, Aunt Mary, that is what will happen. That is what will happen. So nobody else will have any entitlement to this property but Aunt Mary. And anything else is said, what you must get stated in the trust is what you must get. Similarly for you, and similarly for you. So there is no conflict. You understand? A will is a statutory trust. What do I mean? The difference is that the trusts most times are created in the lifetime. So the distribution is already set. That's the living trust. The will is a statutory trust. It speaks after death. Right? So by law, after the death, whatever the will says is what will happen. The difference is, if you don't make the will, it can't happen. When you create the trust, it will happen. So you either create the trust or make the will. It's the same means of providing for. Right? One you do, that the provisions will take place after death. Usually with the trust, it is about some manifestation of something. That if you are a child, a minor, upon your 21st birthday, this property is passed to you. So let's say today is your 21st birthday. This property is passed to you. But your parents who created the trust are alive. Are alive. You see? It is the act of what was stated in the trust, whatever it is to happen. So if it is your 21st birthday, is the act that need to manifest. Upon that manifestation, the action will come to fruition, to reality. Right? Even though I who created the trust is alive. Right? The opposite is the will, that you cannot get it until the person dies.
One question while you're going along. Is it a cheaper way of distributing the estate, creating the trust?
It is a cheaper way in that you don't have to go through the court. You don't have to go through the court. So you don't need to employ an attorney to do a process in the court. The trustee, that is the institution or attorney, whoever it may be, will do the act. However, there's still a charge by the trustee of 6%. Right? So that is the Trustees and Executors Act? Yes.
Thank you.
You're welcome.
I have a question.
Yes.
How long after death can the executor
Okay, so the executors are required to begin probate proceedings 7 days after the burial. After the burial. Yes. To begin probate proceedings is to go to the court to apply for probate, but not 7 days after death. Because there are persons who burial 2 months after the death. So you can't start distribution before the person buried. No. It says after the burial. Understand? Yes, I've seen some cases where persons died in all 3 months. Them not buried yet. And I'm like, what's up with that?
When is the will read?
The will should be read anytime after the burial.
All beneficiaries should be there.
Yes. So as the executor, on the day of the funeral, I don't recommend that. Allow the day for grieving. Allow the day to pass. 7 days after that, you call the persons that I wish to do this in your presence and set up a meeting. You have to allow grief to happen, right? You might grieve in a day, some people in a year. Understand? You cannot measure grief because you don't know what I am feeling, right? Some persons, when the relative die, Their first sight is to see what they can take. And another person is on the ground bawling and wailing, sobbing in sorrow. But you still have to allow time for grief. So I'll say 7 days after the burial, you call a meeting. Even the day after the burial, you can make an announcement that 7 days' time you wish to meet with all Ahono to read the will. All right? Yes.
My last question is, when the will is being probated, can the assets go into the executor's name?
After the probate is done, the law requires for property and shares, transfer for property and shares is what attracts transfer tax. Let me go again. Transfer tax on property and shares only is charged. Transfer tax is not charged on motor vehicle, bank accounts, and things like those. So, property and shares require an instrument of transfer. That's a document that they'll have to do at the Tax Administration Jamaica. What it allows for is for the executor to be entered on transmission. To be entered on transmission means that the asset is passed from the deceased to the executor who holds to pass to the beneficiary. So the executor's name is entered on the title on transmission, not transfer. There's a difference. Let me explain that. Transmission means that the property is passed from the deceased to the executor as the holder. And transmission means to transfer. To transfer. And transfer can only be made to beneficiaries. Or, if by default, meaning that the liabilities and debts affect the property, that the executor has to sell the property to be transferred to the purchaser. But in both instances, whether transferred to beneficiaries or to purchaser, the executor has to be entered on transmission to hold, to transfer. To transfer to beneficiaries as beneficiaries, or to purchaser as purchaser. But it doesn't mean that the executor is owner. No, that's what transmission means. It doesn't mean they are owner.
Question to you, Mr. Morris, with regards to choosing your children to be executor. How you do? How you do it? You choose one of the more responsible one?
Yes.
Okay.
And that may vary from person to person. Because you have persons who have children they can't trust. We know because we see estates come, and when the estate come, the mother would have put person A in the account, right? Just for convenience. And when the mother died, person A emptied the bank account. Even before the mother died, person A emptied the bank account. All right? So who do you trust? I don't know, but you need to make a choice. So you have to do some screening now to say A, B, C, or D, who is most trustworthy, right? But the thing about it is that for executor, you can choose more than one.
Okay, that's what I wanted to
You can
ask.
choose more than one. So what that means now is that it needs co-signature.
Excellent.
So no one person
That suits me
can
well.
arbitrarily do so and take out the money. All right? So it will need signature of the co-persons, co-executors.
The final question, Mr. Morris. With regards to a trust and a will, is there any disadvantage in having a trust to a will?
No,
Disadvantage to the testator that I'm
No.
asking? No, none at all.
there's no advantage or disadvantage. There's what works for you and what doesn't work for you. That's the truth. Because you may do a trust and that works for you. My sister here could do a trust and it doesn't work
How will it not work for her?
in terms of advantage. Right? It may not work to the advantage. There are persons who make a will and they give the property to A. And whilst they're alive, the relationship between me and A went south, break down, gone sour, went bad. Yeah? I do over my will and give it to my sister here.
That's my concern.
Right? So, was this the wrong choice? No, at that time, it was the right choice. So if you make a trust, right, this is what was happening that works for you at that given time. Right? Now, at the time the trust materialized, things may go on south. For example, you have your child and you create a trust for this child who is 15. And the trust stipulates that on the 18th birthday, the child is to get this house. Right? You're still alive. The child is now 18 and the house passes to the child. And the first thing you see the child do is start to invite friends and have party and the place start to deteriorate. And you say, no, I worked so hard for you to get this and look at what you're doing. Huh? What if it's money in the bank and the child gets the money and the child is out having a grand time partying and drinking with friends, and before you know it, the balance moved from 10 billion to 1 million in a matter of weeks. All right? And personally speaking, we have such an estate where a child came on the 18th birthday, got $1 million to allow us to complete the process for him to get the next $9 million. On the 18th birthday, he got $1 million. Why? Because we have to do what is called a final account to pay out everything. But he wanted some money now. So we pay him 1 out of the $10 million for the now. The gentleman came back 2 days later and asked for the rest of the money. And I said, but we told you to allow us some time to do the final accounting to get you everything. 2 days is not sufficient. Right? We gave you $1 million. What happened? The money done. When we heard, the gentleman took the money and rented a yacht and had a boat party with his friends. Rented a yacht and had a boat party. So the $1 million went like that. Right? Yeah. So you can have that in a trust and you can regret it. But at the time you created the trust, that was the best thing. What do? You can't rip it up. It already happened. It is different for a will. If you made a will and you see this happening, you can tear up the will and write a new will and give it to another child. Understand? So the thing is that no, because the trust already materialized. Yes, you cannot change it when it materialized. The trust was for the child upon the 18th birthday. The child is now 18. You can't retract the trust. Right? So the thing is this, there's no best practice. There's what works for you. Making a will, putting their name on the property, putting their name in the account, creating a trust. Anything that works for you works for your circumstance. My circumstance may be different. Huh? I will have my child and I say, listen, this money is for you, that you will be able to start life and that you don't have to go through some of the struggles I went through, right? And I'll give that child that money and that child take that money and go invest it, right? Same situation of giving money to a child. The difference is what your child did with their money and how my child react with that money.
Okay, Mr. Morris, we have two final questions.
actually
Alistair
three.
McBean and Winston Barrett, and then
No.
we'll have the vote of thanks.
No, there were some other questions, but there's a question here. Just one question as it relates to a trust. Can a trust own property? And can you set the letters of a trust to span generations? So all your assets would be kept in a trust in Jamaica,
Yes.
and you just administer on the trust?
Yes.
Mhm.
Yes. You can have that, right? You can have the trust for the generations. So this property is kept by the trustee, right? So the trustee is now responsible for the maintenance of this property. However, there has to be a trust fund to generate the income for the trustee to maintain the property, right? So that all the generations will come here at some point in time, they will come and rest, move on. If they should go out, start life, and hit at the brick wall, falter, they can come back, rebuild, and such. So it can be according to what you want.
Thank you, Mr. Morris. There is another question at the front, and then Mr. Barrett.
Oh, my question, should a beneficiary hire legal representation if the executor hasn't provided notice or an update regarding the estate?
Yes, you can. So an executor is in charge of the estate as the legal representative. But the executor, remember, holds the asset to transfer to beneficiaries. Therefore, the executor is accountable to the beneficiaries. So an executor cannot use the estate for his personal gain. An executor cannot use the estate in any way disadvantageous to the beneficiaries. Yeah? So the executor holds this property on trust to transfer to you, the beneficiary. 6, 7 months, 2 years has passed, and you have not yet gotten the title transferred in your name. Why? Because the executor rent it out to him friends and families, and he might collect that money. So he cannot benefit from it. So yes, the beneficiaries can take legal action against an executor.
Thank you, Mr.
The
Morris.
Executor and Trustees Act, there is an act of law that says the do's and the don'ts. So you have to be careful as an executor that you are not in breach. Hence, you'll be in liability. No, the executor gets 6%. Huh? At point of starting to completing the duty. So it's not at the start. At the start, you can start the payment and then end the payment upon completion. No, 6% of X. 6% of X. So if I want to do that, then it's for me to drag out the estate. So I continue getting monthly payments. Huh? But does this monthly payment amount to 6% or more or less? It might surpass. All right? Yeah.
All right, we have a
So
question.
if let's be fair, if that occurs, the executor must be made to show the executor is still accountable. Right? There's a document in the legal proceedings called an oath. It's called an oath. An executor signs that oath. And one of the statements is to be fair and just according to the law and to give an account whenever required to do so. That's a clause in the oath that the executor or administrator of an estate signs. So it's not to use the asset, all right? They will have to give an account.
All right, thank you, Mr. Morris. Quick question here.
In a tenant in common situation, do you need two separate will or you can have a joint will?
Okay, wow, joint will is the worst thing you can ever do, my brother. I have a client who wants to burn down Parliament because his parent made a joint will. His parent made a joint will, and he want to burn down Parliament. Here's the thing. Yes, if you have a joint will, for anything to happen, it requires a joint debt. The will becomes effective upon death of the testator. Thank you very much, Pastor. Therefore, if you have two testators to the will, how much person must die? So here's the problem now. His father and mother made a joint will for a motor vehicle. A motor vehicle. His father died. His mother is alive. But nothing can be done until the mother dies and his mother is alive. And when I said that to him, I'm like, how can a stupid law this? No, son, me need to know who in a parliament. I tell you, here's a sad thing. The motor vehicle is just going to sit and rot. Because him now have no authority to drive it. Understand? And the mother cannot transfer it because the joint with the father will cannot be probated because it joined with the mother who is alive. You realize that one cancels the other and vice versa? Huh? The car is owned by mother and father jointly. The will was made jointly because the car is jointly owned. Watch this now. The father died, the mother is alive. Right? The car passes to the mother as the joint owner. However, because the father, she has to probate the will for the father who is dead. But the will is joined with that father and her. So it doesn't become effective until she dies for it to be transferred to him. So she can transfer to him the son because the father is dead and she is alive. Joint will is the worst thing. Please don't do no such thing. All right? Now, you mentioned joint tenants. Joint tenants is where you have an undivided interest in property. All right? Once it is an undivided interest, both parties have to sign. Right? Should you make a will to say, I give this property to A, right? The will, that gift, the will is effective, but that gift is ineffective. Why? Because the property is owned as joint with you and the spouse, right? It is an undivided interest, meaning it's not divided, separate. Because it is undivided, you alone cannot give it. Both of you will have to give it. That was what led to the gentleman's parents creating a joint will. That was the narrative that led to them making a joint will, that both of you will have to give it. Okay, so both of us make a joint will. No. You make a will, your spouse make a will individually. Now what happens is that in the event of A dying before B, then B's will can effectively give it. If B dies before A, then A's will can effectively give it. My sister, you related a situation with you and your husband traveling together. Anything could have happened and both parties die. Right? Yes, these things happen in life. Yes. Now, in a situation like that, if there's a joint will, you would have to establish who died first. Plane in the sky crash. How you know who died first? These are problems that persons get themselves into.
Two separate wills, sir.
Here's it. When you have these situations, get legal advice.
Yes.
Call an attorney, call administrator general.
Yeah.
Get legal advice. Because there are persons who have these living situations. Right? But joint will is not the answer. Both parties make a will. When both parties make a will, it is conditional to who died first. So if A died first, then the statement in A's will is ineffective. Why is that ineffective? Because it is a joint interest, it passes to the survivor automatically. So husband died, and in husband's will, it says the house at Bromelia must go to child A. But the house is owned by husband and wife jointly. Under the Common Law Act, the law of survivorship, upon the death of one party to the joint ownership, it passes to the survivor, which is the wife. Therefore, in the husband's will, giving this property at Bromelia to the child, it's ineffective, it's not valid, because the interest automatically passes to the wife. Right? There's a precondition that is required in such an instance, in that the wife's will that she made, the precondition would have been satisfied because the husband died before her. So the precondition is that one person have to die before the other. So this is the property at Bromelia. A husband and wife own it. Husband would have to say in his will, if my wife Primrose should die before me, I give this property at Bromelia to. Right? If Primrose died before the husband, then the gift is effective because the interest passed to the husband. All right? It's hard to understand. It takes legal mind to understand. And that is why I said, for these circumstances, get legal advice. For joint tenants, yes, go ahead. For joint tenant, upon the death of A, it passes to B. No. So remember now, joint tenant is an undivided interest. So let's say this is the property, Bromelia, jointly owned with you and your wife, right? You will now put in your will to say, my share of Bromelia I give to whoever, right? Remember, it is undivided. If it is undivided, sir, you cannot identify my share. There is no such thing as my share because it is undivided. Tenants in common is the divided interest. Where it is divided, sir, you will say, my share I give to. Right? Because it is yours, it is divided. So whatever interest you own in this property, be it 50% or even 5%, because a lot of people think that tenants in common is 50-50. No. It is a divided interest. The question is, what is the ratio of division? Huh? Is it 60-40, 70-30, 80-20, or 90-10? Yes. So it is not always 50-50 for tenants in common. It can also be a ratio, a divided ratio. Yes. So let me just finish. So tenants in common, the difference is one is divided. Yes. Joint tenants, the interest is undivided. Right? Just think of it that way. Joint tenants, undivided. The whole is one. Tenants in common is divided according to the ratio. Yes.
I ask
No. Oh.
The surveyor came back to say that there's a breach. Neighbors swinging onto the other, we swing over to the other, and so on. So I called NLA, and NLA says, yes, there's a problem in the area. Now my challenge is that one of the neighbors died, son took over, we're not in contact. The other neighbor said that we have to pay them for the swing. And you know that when you have something like that, you can neither buy, borrow, nor sell. How would you advise?
Buy or sell. Buy or sell. Remember, the breach is to buy, to sell, or if it can be destroyed, meaning if a something can lick down, you lick it down. So if it is a fence that built on your side, you lick it down. So if they don't want to buy you out, or you don't want to sell to them, lick it. Shift the wall, you have to lick it down to shift it. So you lick it down and bring it within the correction. Right? So in such a situation, it's not difficult. It's going to cost you to correct it. Yes. It's either you buy out the person or the person buy you out. Right? That's the solution. Right? Because, and that happens a lot of times, persons encroach. It's called an encroachment. Right? Where mostly walls have that. People, they're building the boundary wall, and this is the boundary peg. But somebody moved the peg. Right? So in estimation, them say, about, I think of this right there, you know. Come on, put it this, I think of this. And then build the wall over the encroach. Right? What is the difference in space? 1 meter. What it value? 100,000. John, are you willing to pay Mary 100,000? Mary, are you willing to take 100,000? Right? If they say yes, then you do the resurvey to show the movement, the shift. All right? And you know, have to go back to Parish Council, get the approval, and then go back to National Land Agency to show the new registration of the diagram. So that new survey diagram will annex to the title to show the new boundary. Huh? You'll have to pay transfer tax, you'll have to pay stamp duty. So that's why I said it's going to cost you, because you will now need an attorney to do this transaction. Yes, it's going to cost you. it's not about X want, it's about a valuation report. No, X cannot want, X, okay, X may want $1 billion. Well, you have to go give me $1 billion for the 1 inch. No, the legal way is to do the valuation. So as I say, if it's 1 meter, whatever that values, X, are you willing to give me 100,000? B, are you willing to receive that 100,000? Right? Now, if X is being unreasonable and say, no more 500,000, but the valuation report say 100,000, then you bring it to the court. You seek redress in the court. Things like these, laws don't necessarily say that X should ask for 100 when it value 50 or 500 when it, no. The law said that A and B need to come to an agreement as to what the encroachment is. So if you come to agreement to say, all right, I'm going to buy you out, you buy me out. Fine, we agree. Get the valuator. Right? So this is where you have to be careful now. The valuator can't be my friend. And the valuator can't be your friend. Yeah? So, you find a neutral institution and you get a neutral valuation. Right? Yes. And if there's disagreement, seek redress in the court.
Okay. This was a fantastic session. And yeah, I think we have learned so much. Right? And the good thing about it, a lot of what was said is recorded, and you can revisit it. I'm sure we can find a way to get all the remaining questions forwarded. But I think we have reached a point now that we have to bring this meeting to a closure. I'm going to invite Sister Henry to come and do a vote of thanks first. And then I'll ask Pastor to do the last closing prayer.
It was good.
Thank you.
Those of us who are here, you need to give them team a hand of applause. Yes. It's extremely good. Wealth of knowledge, Mr. Morris and the team. Wealth of knowledge. I'm sure you would ask us, we have learned so much. And to those of us who had no knowledge, it has arisen something within us, yes, to start thinking about estate planning, about our wills and what have you. But we have learned so much today. And you have taken so much time, Mr. Morris, to go through the things, to explain it, to make it look simple and so relevant. That are happening around. Yeah. So I really want to say thank you.
You're welcome.
For coming out today. You came from
Spanish Town.
Spanish Town. All right, Kingston, here. You come all the way to Mandy. We are so happy to have you in fellowship today and sharing this knowledge with us. It was a good session. We are indeed grateful. And we pray the blessings of God as you go. And I'm hoping this session is recorded, that other communities may hear, and it may just push them, invite you, come again to them. So I'm hoping that this will move forward. But it's good for all of us. We're very happy, we're very thrilled. And we pray God's blessing as we couldn't, all the questions could not be dealt with today. You understand, we're just going along. So we just have to call it a day. Thank you on behalf of all of us.
You're welcome. All good things must come to an end.
Thank you all. Let's stand. We go from here remembering it's a matter of who gets the legacy. Be wise in your planning. And if you have need to leave a house for the church, it's okay. Pastors don't usually ask for things for themselves, and that's wisdom. But should there be, you should also consider. All right, let's pray. Heavenly Father, we are so grateful. You provided information, truth to guide us in this life. We heard in the first service that if we take heed to your word, you will give wisdom. And we can so plan aright and expect good success for the next generation. We thank you for the session after the one just ended. We pray thy peace over those who shared with us and the substance that they have imparted to us. May we, O Lord, continue to be educated, and that we will share with others, and you will give us courage to make adjustments or to do what needs to be done at this point. May your Spirit lead us onward to victory, for yours is the kingdom, the power, and the glory, both now and forever. Amen. The Lord bless you. Thank you all. You note the first service that I led, I ended right on time. The second service, I told you it would have been shorter, but you keep asking questions because you had a deep interest, and we want to commend you for doing the right thing. God bless you.